Ready? Start. The faulty repair to the transformer resulted in a loose connection that led to the catching of fire to the transformer, and all the cars in the parking lot were burnt in the fire, which resulted in suffocation for viewers of the cinema in the hall. Full stop. Further, it was held that case there was an addition of 8-seater box that closed off the exit on the right side of the balcony. Full stop. It was also found that the owner of the cinema had added 52 additional seats to the theater, which booked the gangway on the right side of the movie hall. Full stop. In the aforesaid case, both A1 and A2 were found guilty not by virtue of their position in the company, but rather by virtue of specific allegations made against them. Full stop. In the aforesaid case, accused themselves were found to be occupiers, there were gross statutory violations, which had a direct nexus with the death of the victims. Full stop. Further, looking at the facts and circumstances of the present case, the said case cannot be applied against the appellants accused. Full stop. Stanza. Having regard to the case law referred above by applying the facts of the case on hand. Full stop. We are of the view that the case of the appellant accused number 2 Shiv Kumar Jatia in criminal appeal at the rate SLP within bracket criminal number 8008 of 2018 falls within one of the categories enumerated in the case of State of Haryana versus Bhajan Lal to invoke the inherent powers under section 482 of CRPC, either to prevent the abuse of the process of court or otherwise to secure the ends of justice. Full stop. Stanza. In the criminal appeals at the rate SLP within bracket criminal numbers 10054 to 10056 of 2018, the sister of the victim has also questioned the directions issued by the High Court allowing them to appear before the trial court through an advocate and by permitting them to appear as and when there is specific direction by the trial court to appear before such court. Full stop. It is the case of the appellant complainant in the above said criminal appeals that while dismissing the criminal miscellaneous cases filed under section 482 of CRPC, the High Court has committed error in issuing directions as referred above. Full stop. It is the case of the said appellant that to dispense with personal appearance and allowing the accused through an advocate can be considered only by the magistrate under section 205 and oblique or 317 of CRPC. Full stop. But without recording any reason, the High Court has issued such directions which are impugned in the appeals. Full stop. Overall.